This is Ex-Con Mike from After Prison Advice, and this is Gun Rights for Felons Part 3 with one big-ass correction. Stick around. Okay, so here's the situation. In the comments section, there's been a lot of controversy about whether or not you can get your rights back, whether or not apply to the ATF and they'll give you your rights back, whether any of these things are true. And it turns out that I was right on some and I was wrong on one big thing. So let me just clear it up. I Googled ATF rules on gun rights, which brought me to this page. And I saw this. Is there a way for a prohibited person to restore their right to on atf.gov? So I clicked that, which brought me to this page. And now, most frequently asked questions, ask firearm questions. So I click that, and it brought me to this page. And the first question is, prohibited persons NICS denials. Number 1, I have been convicted of a felony. How do I reinstate my rights to possess a firearm? So I'm just going to stick with that. Forget the black powder. I'm just going to stick with that and go down. We got to scroll down until you get to the question. And I read this and I reread it and I reread it. Because the first time I read it, I read it with the same understanding I've had every time I've read this in the past. But since people have been so sure that they're right, I read this a bunch of times. Now, I'm not a lawyer, but I believe I got this wrong. I believe that, well, let me just read it. Persons who have been convicted of a crime punishable by imprisonment for a term exceeding 1 year as defined by 18 U.S.C. 92(1)(a)(20, and this applies across the country for any crime, are prohibited from receiving or possessing firearms under federal law, 18 U.S.C. 922 GL or 1 or whatever the hell that is. Felons whose convictions have been set aside or expunged, or for which the person has been pardoned or had their civil rights restored, are not considered convicted under section blah 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 unless that person was expressly prohibited by the law of the jurisdiction, the state where you were at, in which the proceedings were held, from possessing firearms. Admittedly, I get to the first part, and for me and my convictions and the number of convictions that I have, I read the first part and I don't even continue on, because the fact of me and the number of expungements that I would need in order for me to obtain firearm rights through the federal government and even apply is way, way out of my league. So I admittedly didn't read thoroughly about the other part. Just to cut in and explain my position on where this misunderstanding came from. It's only a misunderstanding now. I'm old. Back in 91, I caught some cases, and because of those cases, I lost my gun rights. And in 94, when I caught another case with a gun, one of my charges was being a convicted felon in possession of a firearm when I had not yet retained my gun rights back. And through my trial and learning about the law and in my appeal, fighting a short barrel shotgun charge, I found out from my appeal attorney that, and I found it out through the case law, that if I had won my shotgun charge in the state courts, the feds, because of a violent crime with the use of an illegal weapon, the feds could have picked it up and charged me with the whole thing again under federal law, and then I got a parole from the state to the feds or some crazy shit like that, so I dropped it. That's where my understanding of the ATF law comes from 1991, 1992. Because back then you had to apply, you had to get it from your state and then apply to the ATF. Well, apparently back then is when they stopped it, but I didn't follow through because I was in prison. I'm recently learning about this gun shit because I personally haven't pursued it myself to get my rights back. So that's just that. I'm getting back to the video. But what it's saying here, persons convicted of a state offense, because see, here's the thing. The ATF is not allowed to act upon any applications. Here, I'm just gonna go get that right quick. Okay, so in this same Google, ATF rules on losing gun rights, this one came up, cgact.gov. And you click that and you end up at this page right here. And this page says Federal Law and Gun Rights Restorations. This is the 1968 Gun Control Act, but this is the part that's important. Since October of 1992, Congress in its annual appropriations or annual budgets for money has prohibited the Bureau of Alcohol, Tobacco, and Firearms from using appropriated funds to investigate or act upon applications for relief submitted by individuals. Bureau of Alcohol, Tobacco, and Firearms claims that as long as this ban remains in place, it cannot process applications. In this Thomas Bean case, Thomas Bean is a convicted felon. He applied for reinstatement of his firearm privileges with the ATF, not with his state. He applied with the ATF. The ATF returned the application unprocessed, explaining that a provision in its annual appropriations barred it from expending funds to process application. Thomas Bean sought relief in federal district court on the grounds that the Bureau's inaction constituted a denial within the meaning of the law and was thus subject to judicial review. The ATF contended that the court lacked subject matter jurisdiction because an actual decision by the ATF was a prerequisite for judicial review, and the Bureau had not denied Thomas Bean's application. The district court sided with Bean, and the appeals court affirmed the decision. So he won. But then in a unanimous decision, the U.S. Supreme Court reversed the lower court's ruling, finding that an actual alcohol, tobacco, and firearm decision on an application was a prerequisite for judicial review, meaning that you have to have a no before you can ask for the courts to review it. And inaction did not amount to a denial within the meaning of the law. And according to Justice Clarence Thomas, who wrote the opinion, mere inaction by the ATF does not invest a district court with independent jurisdiction to act upon an application, because the application jurisdiction remains with the ATF. This part right here is saying something that the ATF says, but I'm going to read it from the ATF paperwork because that means more. From the ATF, for everyone who's saying about the federal gun cases or federal felony cases, this is the ATF is saying is if your conviction is for a federal offense, you would regain the ability to lawfully receive, possess, or transport firearms if you receive a presidential pardon. You can find additional information about such pardons by contacting the Office of the Pardon Attorney online at www.usdoj.gov/pardon. So that's the federal guys. The state guys is where my misunderstanding came from. Apparently, the ATF is telling us here that you need to go through your state, that going to them, again, I'm not a lawyer, and maybe you should ask a lawyer, but I've been reading this, and to me it seems like they're telling us and the courts that they cannot act upon these applications so that they are not the right person to talk to. And the ATF is telling us where to go to get our rights restored here. Felons whose convictions have been set aside or expunged, or for which that person has been pardoned or has had civil rights restored, are not considered convicted under this section, unless that person was expressly prohibited in your paperwork from ever possessing a firearm again. So that's my fault. I apologize for that. That was completely my misunderstanding. You need to go through the state restoration in the state only, it looks like. And with all these new state laws coming out for expungement for firefighters in California, to new expungement laws in New Jersey, to Michigan's new clean slate law with the automatic expungements, I mean, you can go ahead and possibly get your get your gun rights back through the state. It seems like the ATF is saying to both us and the courts that they're not the appropriate people to talk to, that your state is. And if you can get your state to give you a set aside, an expungement, a pardon, then I guess as far as the ATF is concerned, you're good because they can't do anything with the application. But again, I'm not a lawyer, so you're going to want to look this up yourself in your own particular state. But I'd like to thank the commenters for being so sure, because I had to go back and look it up. There was too many of you. I had to go back and see. And admittedly, when I read it the first time, again, I read it with the same understanding. I had to really read it and think about it. They use all them goddamn lawyer words and shit. But I appreciate y'all clearing that up. I don't want to give bad information. And lastly, let's keep in mind this article here was written January 16th, 2021 from the Milwaukee Journey Sentinel. The protesters who love their guns could lose them if convicted in the U.S. Capitol siege, riot, protest, whatever you want to call it. If you're charged with a crime, almost any federal offense punishable by at least 1 year in prison can trigger the gun ban. And what we saw earlier, what we're going through to try and get our guns, these non-felons that went, that is losing their gun. That's not just us. This is how normals will lose their gun for things like that. And another guy, so if you don't go through your state expungement, you can't even have ammunition. This guy is being charged with being a felon in possession of ammunition in New York. He's a state felon being charged federally. From his online activity brought him scrutiny, and he's being charged federally with being a convicted felon in possession of ammunition. He doesn't even have a gun. I didn't realize that either. So I learned something new with that. Yeah, you gotta go through the actual process to get your rights back. If you ever have any questions about your gun rights and restorations, you should first get with your state government. They have a process for that. Most states do. I realize some of them don't, but most states do. And if you go through that process, you're good. Thank you for watching. If you're a fellow felon and you like my channel, support my hustle by liking and subscribing. If you're a non-felon, buy my book. My author name is Hex the Helpful Ex-Con. You can find me on Amazon. I'm reasonably priced. Hopefully you don't need it. Stay safe and stay free.